Hello, Janice.
Hello, Anthony.
Today we'll cover the risks of being an executor. So what are the risks of being an executor? The main thing is, well, first of all, executors have a lot of power and responsibility during probate. But correspondingly and fairly, they are super accountable for everything that happens with the estate.
Everything.
Yeah. So we'll cover how an executor has risk of even personal liability, how long that risk exists or how long it lasts, and how, for anyone who's thinking about getting into this or choosing their executor, how an executor can protect himself from these risks. Okay? All right. So yes, an executor can be personally liable for estate's debts, taxes, and just anything wrong with the estate. Well, first, the court would the court's first reaction to if they discovered the executor made an error would be to deny payment of the executor's commission, meaning his fee for serving as executor.
So that means you worked for free.
Good job. Thank you for your service.
Very hard job for free. Yes.
But if that's not enough to cover the court-determined error in your service as executor, the next level is your personal assets are up for grab. So that's your home, your bank accounts, potentially your IRA, 401k. Those are all potentially legally at risk if the court rules that you screwed up or that the executor screwed up. A lot of folks don't know this when they agree to serve as executor or when they're naming somebody else to be their executor. They don't realize what they're asking somebody to do. Yeah.
Yes, it is a risk.
So it's not just the obvious, like there was a tax bill, I saw it and I didn't pay it, so I should pay it. I might have to pay. I might be personally liable for paying that. There are other scenarios that are a bit more nuanced where an executor can be held personally liable. For example, the executor sells a piece of real estate, but months later at the closing of the estate, the heirs dispute the purchase price and think you didn't get a good enough price. Right. There's tens or even hundreds of $1,000s you left on the table, and we deserve that either from your executor's commission or from you personally. There's also the more nuanced situation where an executor might fail to pay a knowable tax, even if if they never actually received notice. That's a scenario that's very gray, but yeah.
Yeah. If you know it exists, property taxes and such, but you don't pay, you should know it's there.
Or you should have gone to the steps to find out if those taxes exist. Yep, which we'll talk about in a minute.
The legwork to find these out. Yep.
So that leads us to the question of how long is an executor liable for estate debts, taxes, and what have you, and how long does this personal liability last? Okay, so the scary thing is theoretically forever.
Boy, this podcast is going to make everyone jump for taking on this role.
I mean, yes, look, there are limits and steps you can take to protect an executor and just kind of end the job and say, okay, my risk is done. But practically or in reality, an aggressive lawsuit can get around most of these limits. So that's what I mean by theoretically forever. So for example, in most states, creditors have a certain process and a time limit within which to file what are called verified claims. And only if you follow this sort of specific legal procedure are you a official creditor with your verified claim. And therefore, in that scenario, theoretically, your executor would not be personally liable for a debt or amount owed to a creditor that did not follow those specific rules. Okay?
Yes.
However, an executor, even in the absence of these, verified claims, these formal notices from the creditors, can still be held to have constructively known about the debt. We see that all the time in legalese, right? Constructive knowledge, constructive contract.
Yes,
and in fact,
should have known.
Yeah, if they should have known, then an executor, or if a judge rules that they should have known, then yes, an executor can still be held personally liable, even if that creditor never filed their proper court steps claim.
Correct.
Then there's the example of receipt and releases. We do this all the time, and many of our clients are probably familiar with these. When you close your estate, when an executor closes the estate, they ask all of the heirs to sign a document called a receipt and release, which says the heir accepts the check as the full and final amount of their settlement, and they agree not to sue the executor for more later. Okay?
Exactly.
So theoretically, this document is like your ironclad protection. Like, hey, you can't sue me. You signed a document that said you never will. But anyone in the legal world, I know, right? Anyone in the legal world knows there's ways around stuff like that. The heirs will argue. I'm not trying to give ideas out here, but
right.
Any heir who hires an attorney will find a way to argue that, oh well, I only signed this because the executor failed to disclose something, or the executor, was not transparent about this. So that receipt and release that's in the garbage because it's not valid.
Right.
So is everyone, like you said, jumping at the opportunity to be an executor now? With all these risks?
Not so much. Yeah, not so much.
Well, the good news is there are ways to protect yourself if you're an executor, and we'll go over a couple of those now. Number 1, get your tax clearance.
Yes.
Do not distribute funds until the IRS and the state level have confirmed that you're good to go. They have procedures, even though they're painfully slow at times, but they do have procedures to release and formally release an executor from that personal liability. The form actually says on top, discharge of executor from personal liability. I mean, there's a set process for it.
Yes, and that is big. That is your key to I did this right.
Yep. And because if you fail to do that, or if you even fail to search for a tax that was owed and that you didn't even know about, these taxing authorities will come after you and slap you with a completely unexpected and potentially large tax bill. We've actually had the misfortune of having gone through that a few times before, but luckily we were able to, because of some of the other steps, we were able to get through that.
Yes, yeah.
Next, when you close the estate, you want to do a full accounting with receipt and releases. This is the accounting we talked about in the past are the books and records of the estate prepared in the court-approved format where you're disclosing to your heirs everything that happened. This is your full disclosure. Like, here. You can't,
start to finish.
Or theoretically, you can't argue later that I failed to disclose something because I'm showing you everything. And I'm showing it to you in exactly the way the court wants me to show it to you. So again, it's not bulletproof. We already talked about how the receipt and releases are not bulletproof, but it certainly gives the heirs less wiggle room to argue that they didn't know something or they weren't shown everything because you're trying to show them everything with this document.
Everything. Every penny in, every penny out on a silver platter. Here
Exactly.
It is.
Yes. Next, keep a reserve. Again, we've talked about this in the past. Hang on to a small percentage of the estate funds. I mean, although the estate is closed for the most part, like, I don't want to put a percentage on it, but for the most part, you still want to hang on to a couple of thousands or maybe even tens of thousands of bucks, depending on the size of the estate. Because no matter how good your executor is, and this, their stuff just comes up. Unexpected taxes, even if it's small, even if it's an accountant fee or stuff. Janice, you've seen it. Stuff just
we have seen. Yes, just little things down the road. Yep.
And executors, you don't want to have to pay for that out of your pocket. But if you're trying to go back to all the heirs and say, "Hey, I need $500 from each of you to cover this bill," good luck with that.
Sorry. Yeah.
See how fast those calls get returned.
Oh yeah, they're not. You're not getting your money. I mean, it is what it is. Yeah.
So yeah, have a reserve to cover those things and make it a decent size reserve because yes, sometimes those unexpected bills or taxes can be quite large.
Yeah, and then eventually the reserve does get paid out to everybody.
Of course.
Yeah, it just you are taking a little bit of time to make extra sure that you won't have to deal with any issues.
Absolutely. And our last self-interested, to be honest, advice of how an executor can protect themselves is to not be the executor and to hire a pro instead. Because even with a excellent probate lawyer, amateur executors are the decision makers, and they're amateurs. They're going to be prone to poor decisions, and that leaves them open to risk. So it can just be better to have the actual decision maker, somebody who knows and is experienced in making all of these cost, benefit, risk decisions, not relying on the advice of somebody to help them make a quote unquote good decision. Yeah.
Or Google, right? You're just going to Google the answers, and they might not mean to make a poor decision. It might not even be something malicious. It's like you talked about everything here. It could simply be a mistake or an accident or something little that does leave them open to the risk. For sure. Because they're not familiar with it. So
that's it. This is really for anyone who's considering being the executor themselves or thinking about who they want to name as their executor, because it's useful to know what are you asking of this person. Yeah.
Yes. And so to learn more about what the executor has to do, I recommend Anthony's book, How to Hire an Executor. Probate's complicated, and this is going to show you what your executor needs to do and needs to not do.
Perfect. Thank you, Janice, as always. Thanks, everyone, for listening and for sending in those questions all the time. And we will talk soon next time. Bye now.
Talk soon.